I just called the case. Can I get your appearance?
Matt Keys on behalf of probation.
All right, it's time and date. So,
James Gizicki on behalf of Ms. Williams,
Thank you.
President Court. Ms. Williams had the opportunity to go over her constitutional rights, that has no questions. She's going to enter a plea of guilty to the charge with an explanation, Your Honor.
okay. Ma'am, did you understand everything your attorney just said?
Yes.
All right, and did you go over this probation violation advice and rights form with your attorney?
Yes.
Did you understand your rights?
Yes.
And did you sign the back?
Yes.
Ma'am, you understand that if you enter a plea of guilty, you'll be waiving the rights on this form. You understand that?
Yes.
Okay, and is it your desire to waive those rights after talking to your attorney?
Yes.
Okay, so there will be no hearing if you enter a plea?
Yes.
Okay.
Before we even get into the first word of testimony, let me tell you something. Today's courtroom session is a masterclass in what not to do when standing in front of a judge. We've got two very different defendants, two very different situations, but one common thread: accountability. First, a probationer who thinks she can outsmart science with a non-alcoholic beverage excuse in a courtroom that deals with substance violations every single day. Then, a medically fragile defendant battling addiction, pleading for mercy after violating bond conditions tied to fentanyl use. But here's the twist: this judge? She's not playing games. She makes it very clear from the start: honesty matters more than excuses. And when defendants gamble on unbelievable explanations, the consequences come fast. Watch carefully, because what unfolds isn't just about alcohol tests or drug violations. It's about credibility, choices, and how quickly sympathy can disappear when the truth doesn't add up.
Knowing all of that, this is the second technical violation. I could give you up to 10 days jail. Do you understand that?
Yes.
All right, knowing all of that, to the allegation you tested positive for alcohol on November 27th, how do you plead?
Guilty.
Has anyone forced you, threatened you, or promised you anything to get you to plead?
No.
Are you pleading guilty of your own free will?
Yes.
Okay. All right, I'll accept the plea as knowing and voluntarily given. And Mr. Gizicki, and Ms. Williams, before you give me your explanation, I just want to say I am not an idiot. And if you give me an idiotic why, I'm not going to appreciate it. I have a treatment court here. I have heard everything under the sun that you could possibly come up with. And you get a lot further with me if you tell the truth than if you lie. So I'm letting you know that ahead of time. What would you like to tell the court, Mr. Gizicki or your client?
Your Honor, that's what she consumed, non-alcoholic beverage.
Okay,
And
that's
she asked
what
you a
she's
question.
going with? Okay, good. No, I like that. Good. Go ahead, Mr. Gizicki.
No, that's it.
Tell me more. That's it?
No, that's it, Your Honor.
Okay, well, that's fascinating, and I've never heard that explanation before. This is the first time someone's tried that on me. Mr. Keys, you have anything to say?
Yeah, I mean, the
Second alcohol violation.
correct, on an operating while intoxicated.
With a .24, right?
You know, I mean, at the end of the day, whether it was alcohol, a beer, a non-alcoholic beer, I mean,
Mr.
non-alcoholic beers, almost all of them actually contain alcohol, so
Mr.
there's
Keys.
no way that we'd be able to determine.
No, Mr. Keys, how much alcohol does a non-alcohol, like, let me give you just a hypothetical.
Five, if I.
Okay, so how many would you?
Now pause right there. A guilty plea with an explanation. That phrase should immediately raise your eyebrows. Because in probation court, especially with technical violations, judges hear explanations all the time. And usually, those explanations fall into one of two categories: honest accountability or creative storytelling. Notice how smooth and procedural everything feels up to this point. Rights are reviewed, forms are signed, waivers are confirmed. The system is methodical. But what's about to happen shifts the tone completely. Because when someone pleads guilty yet signals they have a justification ready, that explanation better be airtight. Especially when the judge is already dealing with a second technical violation. That's not a first mistake, that's a pattern. And judges look at patterns, not just moments.
Have to drink, do you think, and I'm not good at math, Everybody knows that, but how many do you think you would have to drink to get 1, 2, 3, 4, 5, 6, 7, 8 times the cutoff?
I don't think I could put a value on it, but I think it
Do
would
you
have to
think
be quite a few.
Yeah, it might be 100, I don't know, for you to get, did you have 100 non-alcoholic beers or 30 in one sitting?
No.
You're very small. So the cutoff is 500 for it to even test positive. So people could probably have or get away with a non-alcoholic beer or two and come in and still test negative, right? It's such a low alcohol contact. And for you to come in at 4,000 nanograms per milliliter, you would have had to have drank. And I don't know, I can get on Google and find out how many you would have had to drink, but it would be a mountain of non-alcoholic beers. So I think you're lying. So now, instead of me following the recommendation of Mr. Keys, you had a 0.24. And then when you got stopped, you were 3 times the legal limit. So that time, I don't know, you must have had 20, 50,000 non-alcoholic beers. And then you've already had 1 alcohol violation. And now this is your second one. And the first one, I tried to give you therapeutic recommendations. You understand you get up to 10 days jail today? Do you understand that?
I do understand.
Okay, so listen, I am tired. I am tired of hearing nonsense. And I told you before you told me your lie that you had choices. You could tell me the truth and come clean and I'll adopt the recommendation. We'll be good to go. Or you can lie to me. And you made that choice. And there's a consequence for that. Because I don't believe for 1 minute, not even, I want you to understand the level of belief I have in what you just told me is negative. Like it's nonsense. And everybody in here knows it. You came in at 4,000 nanograms per milliliter. 5 days jail.
That right there? That's a warning shot. The judge is drawing a very clear boundary before the explanation even begins. When a judge says, "I am not an idiot," it means she's seen every version of deflection imaginable: mouthwash, poppy seeds, secondhand smoke, you name it. Treatment court judges especially deal with substance cases daily. They understand testing thresholds. They understand metabolism. They understand what's statistically possible and what's fantasy. This is actually an opportunity. The judge just told her exactly how to win favor, tell the truth, be accountable, own it. But instead of taking that lifeline, watch what happens next. Because sometimes defendants mistake politeness for gullibility. And this courtroom is about to demonstrate the difference between the two.
Idiot, forthwith. You're not drinking on probation.
I'm not.
Okay, well, you're not now, at least for the next 5 days, you're not.
Court does call the case of the people versus Daniel Cummings.
Andrew Children's attorney on behalf of the people, Your Honor.
Good morning, Assistant Public Defender Lauren Perry on behalf of Mr. Cummings, who is approaching.
Your name, sir?
Daniel Cummings, Judge, Your Honor.
Your Honor, I do have a green sheet. We are requesting an adjournment. We are going to refer Mr. Cummings to the Veterans Treatment Court. He does live out of county, so
Gonna take a minute.
Redford.
Would you be able to get that accomplished by the 30th, or you need more time than that?
Thank you. We can try. See where we can get.
Probable cause conference will be adjourned to December 30th, 2025, 9 a.m. Bond will continue.
Your Honor, Mr. Cummings would like me to address bond.
Briefly.
Your Honor, Mr. Cummings is requesting a personal bond. He is currently in custody with significant medical issues. As you can see, he wears a brace. He has to wear that 24 hours a day. He about a year ago received a back surgery with that involves getting 14 rods in his back. He has to sleep in a certain type of bed, which obviously is not available here in the jail. He also has cystic fibrosis, so he has to wear a vest.
There it is. The explanation, non-alcoholic beverage. On its face, it might sound plausible to someone unfamiliar with testing science. After all, non-alcoholic drinks can contain trace amounts of alcohol. But here's where reality steps in. Trace amounts are just that, trace. Courts deal in measurable thresholds. And probation testing doesn't flag microscopic exposure. It flags significant levels. What makes this moment powerful isn't just the claim, it's the confidence behind it. The defense presents it as if it's a reasonable alternative explanation. But in a courtroom setting, especially with a second violation, credibility is everything. And once credibility starts slipping, it's incredibly hard to recover. Watch how quickly the judge moves from listening to dismantling.
To shake his lungs. He cannot use that in the jail. He also used a nebulizer, but he cannot use that in the jail. He's on about 18 different medications and he cannot receive most of them while in
Shot every day
custody.
for my bone deterioration
His osteoporosis, he says he receives a shot
every day.
every day, cannot receive that in the jail. So these things are accumulating. He is relying on one lung to breathe as one of his lungs is collapsed. So he's really struggling.
That doesn't account
medically.
for his fentanyl use, does it?
No, it doesn't, Your Honor, but
I know, and that's the reason that you're in and why I revoked your bond.
right.
We continue, Ms. Perrini, briefly.
You know, I think Mr. Cummings, this is his first offense, his first time being on bond, his first time ever drug testing and doing anything like this. I think he's really learned potential consequences of his actions. He's been incredibly remorseful to me every time we've spoken. And I think he's incredibly willing to commit to any bond conditions the court may order. He's discussed testing every day and home confinement. He really wants to get home to his wife who has Alzheimer's. He's just really struggling.
May I say something, Judge? Please. I'd like to address, I want to say thank you for locking me up. It allowed me to get off of drugs and I feel my mind is clear, my body's clear. I feel fine. I have no urge to, this kind of place is not for me. I've never been, don't have a criminal record. I've never been in jail. Only thing I did, well, you know what I did, and I just need to get home.
This is the turning point. The judge doesn't just question the explanation, she mathematically breaks it down. She talks nanograms per milliliter. She references the cutoff levels. She essentially walks everyone through the science in real time. And when she says, "I think you're lying," that's not emotional, that's analytical. What makes this so damaging is the contrast. She offered honesty as a path forward. Instead, she feels her intelligence is being tested. Judges can be patient. They can be therapeutic. But they do not appreciate being played. And once the court believes a defendant is being dishonest, sentencing shifts from rehabilitative to corrective.
My wife and my medicines, otherwise I've had MRSA, I've had pneumonia, but that's what's happening. And I need to lay in a certain bed, an incline bed, or my surgery is not going to hold. I got 13 bars in my back, and I will do anything
I'm
and
sure
everything.
talk to the jail medical personnel, though, accommodate you in the best way that they possibly can.
They said they can't give me these medicines. Can I be under a house arrest?
Anything else?
You
This isn't a negotiation, but anything else?
mean I have to stay in jail?
Anything else?
I'm not sure what's going on.
I've listened to you, counsel. I've listened to you.
I'm gonna end up getting sick in here, sir. And can I just be under house arrest? I won't go nowhere.
Sir, we gave you bond conditions. You violated those bond conditions. I revoked your bond because of that. There isn't a medical reason for those drugs that were in your system. You shouldn't have been using them anyway.